with any stall. Sixth, I'm here, my lord. I've just introduced myself.
You are for
The sixth respondent.
seventh respondent, eighth, 9, 10, 11, 12, 13, 14, 15, 16, 17.
My Lord, I'm Daniel Shumba. I appear for the 17th respondent.
You appear on your own behalf. Yeah.
My lords and ladies, I appear for the 18th respondent. My name is Jay Bam.
Mr. Bamu.
Yes, my lord.
$19, 20.
If it pleases this court, my lords and my ladies, T.S. Mnangagwa is my name. I appear on behalf of the 20th respondent. With me is D. Halimani. Halimani. Yes, my lord.
21st, 22nd.
If it pleases the Honorable Court, my name is Isa Mandipa of Gunde and Legal Practitioners. I appear on behalf of the 22nd respondent, and with me is
Sorry, what's your name?
E. Mandipa.
Ndipa.
Yes.
And Makwara.
Mr. C. Mapara.
Mr. Makwara. Uh, 23rd.
If it pleases the court, my lord and my ladies, T.M. Kanengoni, appearing together with Charles Nyika, we represent the 23rd, 24th, and 25th respondents.
So you are appearing with?
With Charles Nyika.
Charles Nyika. 23, 24, 25. Yes, we confirm that, yes?
If the court is pleased, my lords and my ladies, Amabwe,
yes.
I appear on behalf of the 5th respondent.
Fifth respondent?
For the 5th.
Fifth?
Indeed, my lord. I also wish to apologize to the court for coming in a bit late. There were some logistical issues that had to be sorted.
Yes. This is the yes, Mr. Bofu.
Oh, no, I thought it's not.
You are no, just hold on. Yes, we confirm that the names that have been indicated represent the applicants and the respondents who are here present in these proceedings, as well as their legal practitioners who have audience. Before we proceed with the hearing of today, it's necessary for me, on behalf of the court, to indicate how we intend to move from now on. There are, as you are aware, 4 categories of participants in these proceedings. The first category is that of the applicant. The second category is that of respondents who filed notices of opposition and opposing affidavits. The third category is that of people who did not file notices of opposition or opposing affidavits, but they filed documents in support of the applicant. Then there is the last category of people who have indicated they are not going to participate. They would want to be excused from these proceedings. We therefore want to make it clear that we are here for a procedure, a specific procedure, which is oral submissions, the hearing of oral arguments by the and their representatives. Each party will be sticking to the rules of this court. Rule 41 is very specific, it's mandatory. You have 20 minutes of submissions, uninterrupted submissions. At the end of those 20 minutes, your time is up. You'll be switched off if you insist on going beyond that time. No one will be listening to you. You will be talking to yourself. If you want more time, after that, you ask for time. The court is willing, reasonable requests, and we will then give you the time, and then that will be the final indulgence as far as the time is concerned. That is the main argument. In reply, a party has 5 minutes only, and you need to comply with that time. And again, if you have, not just because you want to argue and talk, but because if you feel you have something really important to make, then you ask for more time. We'll consider granting the time if necessary. What we are going to do is that we are going to ask those respondents who have indicated they are here but they would not want to continue to participate to take the floor and indicate that at this stage so that they can then be officially excused participation. Then after that, we'll then hear the category, we'll hear arguments from the category of respondents or people who filed papers not as notices of opposition or not as founding affidavit to justify their locus standi. Would want to hear why they consider that their documents are admissible in these proceedings. And that will be the only question that will be considered. We will then retire after hearing those parties and make a decision whether they have locus standi or not. And only then will we then come back and start the proceedings by hearing the applicants in their order as the respondents who filed the papers. If we find the other parties have locus standi, then they will have to take their turn as we proceed. I hope I've made it clear and that this is a timeline, that's a program we intend to go through today. Thank you. Yes, can we have those parties who want to be excused? The lawyers involved? I think, is it Mr. Bamu? Are you not part of this group? I think it's Mr. Bamu and Mr. Mandipa and Makwara. Are you involved in this category?
My Lord, for
You
18
are, Mr. Mandipa.
No, I am Mr. Bamu.
Sorry?
I am Mr. Bamu.
Mr. Bamu.
Yes.
Yes, you may say something.
For the 18th respondent, we took the position to abide by the decision of the court. We'll only sit in out of interest to follow the proceedings. But we do not intend to be making any submissions outside what we've already filed on the papers.
You don't intend making any submissions, but you would want to remain observing. You will remain or you want to leave?
I would wish to remain, my Lord.
You would wish to remain, that's fine. Yes? Yes?
Yes, I am as well Mandipa for the 22nd respondent. What is appearing from the papers filed of record, my Lord and my lady, is that we abide by the court's ruling. And maybe if I can take this opportunity, that's to correct the 22nd respondent's name. As opposed to William Mugaza, the proper name is Willard Mugaza. So if that minor correction can be made.
It's Willard.
It's Willard Mugaza. Yes. So we took the position of standing and abiding by the court's rule, but would also wish to remain on bar.
But you want to be excused from participating, but you remain at the bar.
Quite indeed, my Lord.
All right, yeah. Yes, permission is granted. You are excused from participating. Anyone else?
My Lord and ladies, the 6th respondents, if you look at the papers that he has filed of record, he is merely sought to assist the court in that there is an issue of interest, of public interest that has arisen in these proceedings relating to the computation of time. So his submissions that have been filed of record really relate to that aspect. It does not wish to side with any party in the proceedings. We wish to sit in and follow the proceedings.
We're also taking now the position of non-participation, but remaining in the proceedings to observe.
Indeed, my lord.
Is it?
Yes.
Fine. All right. Permission is granted. You are excused from participating.
Thank you, my lord.
All right. Yes, can we therefore hear the legal practitioners and the self-acting respondent in the third category of participants or people who did not file the notices of opposition or founding affidavits, but filed documents which appear to be in support of the applicant. Why they consider that they have a right to be heard, they have locus standi, and that their documents are admissible. Who do we start with? Huh? Yes. Can we hear Mabwe? Ms. Mabwe, I think you are at the top of the list. You are representing the fifth respondent.
Indeed, my lord,
Yes.
I represent the...
You can address the court.
If
Yes,
my lords and ladies are ready, I shall begin to address the court. The submissions of the fifth respondent are that it is an interested party in the sense that it has a real and substantial interest in the outcome of the application that is before the Honorable Court, and as a result, has the right not only to make submissions in favor of what it considers to be real and substantial justice, but it also has the right, in terms of the common law, to be heard. I draw the court's attention to Section 93 of the Constitution, which section indicates that unless there is any detraction from the provisions of Section 93, an aggrieved party or candidate may challenge the validity of an election of a president or vice president by lodging a petition or an application with the Constitutional Court within 7 days after the date of the declaration of the results of the election. Before you, my lords and ladies, is a challenge to an election that was brought by the applicant. The fifth respondent was a participant in the just ended elections. Having been a candidate in the just ended elections, he has a real and substantial interest in what the court would determine in the application that is brought before you. He has been cited, and he must therefore respond. That response does not matter whether or not it is in favor of the challenge or against it. The issue is, having been cited, he must appear before the court and address the court, if not on the factual issues that bring rise or that give rise to the application, but on the legal aspects thereof. And you will notice, my lords and my ladies, that what the fifth respondent, has done is to indicate that there is a legal basis upon which his interests, which are real and substantial, ought to be addressed. And in that light, I would submit that he has the locus standi to appear before this honorable court. Whilst traditionally the approach would have been to adopt a strict interpretation to Section 93 and argue that he ought to have brought a challenge to the application because he has taken a certain position, I submit that the purposive interpretation to locus standi is to allow every party that has participated in the elections, cited as a respondent, to bring their position before the honorable court. It is for the court to then determine whether that position is sound or not. What the court cannot do, in my submission, is to close the door to such a respondent and indicate that they can only approach the court via the interpretation of an aggrieved candidate. Unless my lords and ladies have issues that you would want me to clarify, I believe those will be my brief submissions.
Did the fifth respondent understand the notice given to him by the applicant?
Indeed, my lord, he did understand the nature of the notice.
Tell him.
To show to this honorable court if he has any basis for opposing the application, or otherwise failure of which the court will grant the appropriate remedy.
It says that. Look at it, please.
If the court may kindly bear with me. Yes, I'm on, I believe, page 7, which is the notice. Indeed. Take notice that the applicant intends to apply to the Constitutional Court for the order in terms of the draft order annexed to this notice, and that the accompanying affidavits and documents will be used in support of the application. I proceed to the second paragraph. If you intend to oppose this application, you have to file a notice of opposition in the form of CCZ2, together with one or more opposing affidavits with the registrar of the Constitutional Court at Harare within 3 days after the date on which this notice was served upon you. And you also have to serve a copy of the notice of opposition and affidavits on the applicant at the address for service specified below. And your affidavits may have annexed to them documents verifying the facts set out in the affidavit.
Right. That is, you understand that that is an expression of the rules of the court.
Indeed, my lord, I do agree.
And what do you expect from, as a legal practitioner, what do you expect is to be done?
In terms of the rules, one would naturally have to file a notice of opposition.
Naturally.
And,
why do you want it to be natural?
Because that is what the rules provide.
Sorry?
Because that is what the rules provide.
Yes. I agree. Yes, that's what the rules provide.
Indeed.
Was that done?
My lord, I go back to the submission that I made.
No, I appreciate, yes, we do appreciate.
Indeed.
We just need to be persuaded, to be convinced. Was that done?
If we take a purposive interpretation to Section 93 of the Constitution, I would submit that that is precisely what was done.
That was what was done.
Indeed, my lord.
So are you saying you did file a notice of opposition in this matter, Ms. Mabwe?
Indeed, my lady, I would submit that the notice of opposition was filed. The contents thereof may be subject to debate, but the fact of the matter is that it was filed.
Well, was the content opposition, in opposition to the application or not? Or was it in support of the application?
Thank you very much, my lady, for that question. I move the court to go to the interpretation of what I have constantly said, purposive to Section 93.
I think the question was very simple. Was the notice of opposition, as that term implies, a proper notice of opposition, opposing the application and the relief sought by the applicant?
Thank you very much, my lady.
Put another way, what was being opposed?
Thank you very much, my lord and my lady. I'll answer his lordship's and my lady's question in 2 ways. That it was in opposition, I submit it is. In the first instance, you will notice that the opposition filed by the 5th respondent challenges the remedy, the nature of the remedy that is sought by the applicant. I draw the court's attention, if the court may kindly bear with me, but I draw the court's attention to page 529 of the record, where the fifth respondent tabulates what I call the just and appropriate remedy. That is the heading that appears. Page 529. It's volume 2. Volume 2, page 529. You will notice, my lords and my ladies, that the nature of the remedy that is being sought by the applicant is, in the first instance, a declarator that he was the winner of the 30th July 2018 elections. And then in the second vein, he wants a runoff, right? The remedy that the fifth applicant poses to the, or that he advises the Honorable Court, or that he suggests the Honorable Court to take into account, is not a remedy that relates to who was the winner of the election.
So what does paragraph 4 of that same document say on page 507?
507?
So you could read it out.
Whilst I'm cited, I believe it's whilst I'm cited as a respondent, I support Mr. Chamisa's application to invalidate the recent presidential elections. The purpose of this affidavit is briefly to set out the basis for my support of this application.
Yes. Is it in opposition or in support?
Thank you very much, my lady. It is a support that is also coupled with an opposition. The opposition arising in the remedy which the fifth respondent has suggested that this Honorable Court can relate to. And that remedy would not be to declare either the applicant or the first respondent as the winner, but he suggests a remedy that arises from the constitutional provisions.
Ms. Mabwe, what is the essence of what the applicant wants? Is it not that he wants the election invalidated in toto? Isn't that the principal remedy that he seeks?
Thank you very much, my lord.
Is that not the same remedy that your client seeks? How is it different?
Thank you very much, my lord. If we are going to take I would suggest to this Honorable Court that if we take a piecemeal approach to the application or to the relief which the fifth respondent has sought in this Honorable Court, then it might appear like he is in whole agreement with the applicant. The submission, however, that I make is that whilst the primary remedy that he seeks is in agreement with what the applicant is seeking, there is a substantial difference, and it is that substantial difference which I move to this Honorable Court grants him the right to be heard and the right to make submission that he believes is legally tenable.
Don't you agree that he really is a candidate?
Indeed,
he's talking like a candidate, isn't he?
Indeed, he was a candidate, but his position is different from
no, he's taken a position of a candidate. He was a candidate in the presidential election.
Indeed, my lord.
He got results.
Indeed, my lord.
And he didn't challenge. He's speaking like a candidate who's challenging another candidate, the winner. Isn't it?
No, not so, my lord, in its entirety. I would submit
not
that...
Not in its entirety.
Indeed, in its entirety.
But in its part.
In a tone that might identify with the applicant. But that is not, I submit, a basis for the court to deprive him of the right to be heard. Because what the notice requires him to do is to submit a notice of opposition, What may be questionable, I submit, is the content of the notice of opposition, but that it is filed and that the court must have regard to the content thereof is what I submit that the Honorable Court cannot close the door to him on that basis.
Didn't he join Mr. Chamisa so that he also complies with the constitutional requirement of 7 days?
Thank you very much, my Lord. I would believe that if we take the purposive approach to Section 93, the idea was once an aggrieved party files an application, then all the other respondents that are cited who have a real and substantial interest have to file papers. If each of...
That's not the law. The law is very clear. It is the person who is a candidate, who is an aggrieved candidate,
Indeed, my Lord.
who sets the pace.
Indeed, my Lord.
That is the person who defines the case.
Indeed, my
That's
Lord.
the person who defines the limit of the remedies. All others respond, and he tells them, or she tells them, I want you to respond by showing whether you oppose me. You must oppose me. If you don't oppose me, don't do anything. That is a position. That is 93(1) of the Constitution. And that is why there's that requirement of the time limit. You have 7 days within which to decide what status to take. Are you an aggrieved candidate? The law says here are the rights, here is a remedy, here is a position. You are at large. You are at large within 7 days. And you must do what is required by who pretend to be Chamisas.
I'm with you, my Lord, but I would submit that the purpose of Section 93 was to protect the court, if I can put it that way, from being inundated with too many of applications that challenge the same aspect, considering that this is an application that has to be determined within 14 days. And assume all of the 22 candidates are aggrieved.
No, the 14 days doesn't come into it. Please, let's be very clear about the law. There is the first step, the constitutional remedy. Indeed. To an aggrieved candidate, anyone, there's no limit. Any aggrieved candidate who has results which he doesn't want, which he wants to challenge the winner, he has the right. The law says you are free. You have all the protection. That section is to protect those people for 7 full days. Everybody has a right to do what they like if they are in that category. Then we have a person who is in that category, and that is the applicant who exercised his right. Will decide whether in the exercise of the right he actually did the correct. That's something else. But he did exercise his right, and he is before this court. Applicant correctly saying, look, I'm going to court. You were also candidates. I can't just ignore you. You may want to oppose me. He doesn't say support me. He has no right to say that. He says, in that notice that I said read, it's very clear what the applicant is saying to the respondents, all the respondents. I am seeking an order of court setting aside the results of the presidential election. That is the remedy, the relief sought. Set aside the results of the presidential election. Anyone who opposes that, please file a notice of opposition supported by opposing affidavits. And he specified, you do that within a specific time required by the law, by the rules. That is what he said, isn't it, sir? So if anyone else then takes a position which is in of that applicant, he is in the same position as the applicant. But he has a right to do that, as long as he has to satisfy the court that his documents are admissible. That is all we want from you, to satisfy us as a court that these documents, in the form they have been presented, are admissible.
Thank you very much, my Lord. I will draw inspiration from Section 93, which His Lordship has just cited. Section 93 indicates that a candidate may, it's couched in language that allows one to exercise their right. It's discretionary. So a candidate who is agreed. Indeed.
Who can be forced to come to court? It has to be. Why are you bothering yourself about simple things like that? Legally, there's no issue.
Indeed.
It has to be a may.
Indeed.
Because it's a right.
Indeed.
No right can be forced.
Indeed, my Lord.
So let's not hear that kind of
If the court
argument.
may allow me to,
Yes,
to
all
proceed
right.
from that
Yes,
line. That
yes.
once it then indicates that a party may, and a party decides not to exercise their right in terms of Section 93, and then another candidate has decided to exercise the right, and this other candidate is cited as a respondent, then they have to give a position to the court. And I would believe that that is in compliance also with the provisions of the Electoral Act.
Ms. Mabwe, as far as the procedure you are suggesting is concerned,
Indeed.
at what point the procedure is concerned, would the other parties respond to what you, the fifth respondent would have said? What procedure allows them to respond to that? Because I'm sure you're not saying that the court must just accept what the fifth respondent says without giving the other parties the chance to respond. As they would normally be expected to, where a notice of opposition is filed. There is there is then provision for an answering affidavit.
Indeed. And I would submit that the answer to the question would lie with the applicant. Because the fifth respondent is simply that, a respondent, it is the applicant who can then file an answering affidavit and indicate whether or not the position taken by the fifth respondent is correct at law.
No, Ms. Mabwe, I think you are missing the point. The fifth respondent in his affidavit has made serious allegations against the first respondent as well as the 23rd, 24th, and 25th respondents. You accept that?
My Lord, from my reading of the affidavit, I would submit that what the fifth respondent has done on the factual issues is to simply agree with the position of the applicant.
He makes allegations that there have been irregularities. Do you accept that?
Indeed, which allegations arise from the application?
Yes.
And are already before the court?
Yeah, very well. How does the first respondent, as well as the 23rd, 24th, and 25th respondents respond to that allegation?
Thank you very much, my Lord. As I indicated, the allegations arising from the fifth applicants, from the fifth respondents, notice of opposition, are not fresh allegations. They are allegations that are already in the applicant's papers. And if the first respondent or any of the respondents deems that those allegations are of a serious nature and they require replying, I would submit that then they have to resort to the applicant's founding affidavit, because what the fifth respondent has not done is to bring fresh allegations before the court. He has simply abided by the allegations of the applicant, and all of the respondents, I would submit, have already been given an opportunity to reply to those allegations in the founding affidavit that has been filed by the applicant. So no fresh allegations arise from the fifth respondent's notice of opposition, and that would absolve him from being construed in the strict sense as a veiled candidate that is evading the provisions of Section 93, because he is not bringing a fresh case, if I should say, to this honorable court. He rides on.
Basically, what you are saying is that it is not necessary, or there is no obligation on the part of those respondents to respond to what the fifth respondent has said in his affidavit.
Indeed,
that's what you're saying.
Indeed, it is not necessary, because it is already in the founding affidavit, which founding affidavit all of the respondents have responded to. If they want to respond to the legal arguments, then that is a different issue. But the factual averments are contained in the founding affidavit, and the fifth respondent does not take anything from the founding affidavit, neither does he add anything to it. And unless there are other issues which the court would want me to clarify.
If you go to page 525, paragraph 74, you talk about the final voters' roll also showed significant adjustments to the number and the location of polling stations. Is that in the applicant's founding affidavit?
I believe the founding affidavit does make mention of the voters' roll not being completely in place. And
my question is on adjustments.
That might not appear in the founding affidavit word for word, but I would submit that the gist of that contention is indeed carried out in the founding affidavit, not in the exact words. I want to clarify, not in the exact words, but the gist of that argument is carried out.
I thought you had said that, or that you said that there are no fresh allegations or claims contained in the fifth respondent's papers.
Indeed, my lady.
On page 25, all those applicant.
My lady, if I can point this honorable court to page 2 of the application.
Sorry, page?
Page 22, volume 1. Page 22, volume 1, specifically paragraph 4.51 to, yeah, it is paragraph 4.51. So paragraph 4.51 is a challenge on the voters' roll and what it contained. And then what you have, if you juxtapose that against page 525, what you have on page 22, my lord, paragraph 4.51 in its entirety.
Do you not mean page 20?
Unless probably our records are, it's page 22. My record reflects it as page 22. 4.51, it must be 16.
4.5.12. Is that the one?
4.5.16. It's at the bottom where it's where there's a heading, failure to provide a complete voters' roll, if the court is with me. And the point I was making, my lords and my ladies, is if you juxtapose that against volume 2, page 74, what you simply have is it's not an addition, it's a substantiation of the allegations that already appear in the founding affidavit. And if any of the respondents then is aggrieved by the figures that arise on page 526, they already have an opportunity to contradict page 22, paragraph 5.41 to 116, because the allegations are the same. And in that instance, I would therefore submit that nothing fresh arises in the fifth respondent's affidavit. It has filed its opposition, although that opposition may not necessarily accord with what the other respondents may prefer, or it might not accord with what the applicant may prefer. Because it is there, it has been filed, and because the respondent has been cited and he has a real and substantial interest in the outcome of the matter, I would submit that he must be heard. And any interpretation which the court may accord on Section 93 is an interpretation that must give value and make the Constitution a living reality. Unless there are other issues that the court would want me to clarify, those would be my submissions.
Just one, Ms. Mabwe, this thing or the attack upon your papers is that under the guise of filing a notice of opposition, you've actually become a co-applicant with the applicant. Instead of filing your own application, you've used the guise of a notice of opposition to file in papers. What is your response to that attack? That is the direct attack that has been mounted by the other respondents against your papers.
Thank you very much, my lady. And the response that I've proffered to that is, number one, the applicant has been cited and there's a real and substantial interest in the outcome of the matter. And therefore, that citation accords him the right to file something with the court. Whether that something is in favor of an application that is already before the court or not is subject to debate. The fact is he has to file something. The second answer that I give to my lady's question is the interpretation of the rules of court, specifically the CCZ2, which the Honorable Court has pointed out to, is an interpretation that must be purposive, that must allow a party to be heard before the court. The court cannot close the door to a litigant because they have been cited as a respondent or they have not elected to use the Section 93 route. Once they have been cited and they have adopted a certain position, and if that position is legally tenable, then they ought to be heard. The court should desist from a strict interpretation of local standard and allow a litigant that has been dragged to court to present their position. If my lady is answered, I believe that would summarize my submissions before this honorable court.
Yes. Thank you.
Most indebted.
Can we have the second participant in this group? I think we have Mr. Schumer. Yes, number 17. Is it number? Yes, number 17, Mr. Schumer.
Thank you, my Lord, for the opportunity.
Insist on your mic, Mr. Shumba. Yes, thank you. All right. No, it's fine as long as you can get recorded.
Thank you. Thank you, my Lord, for the opportunity to present my reasons for the 17th respondent being before this esteemed court. Firstly, Your Lordship, I was served with the papers, and I had an obligation to respond to the issues therein. It's important, Your Lordship, that I give a little synopsis as to why this court must hear me and my arguments. Firstly, I was a candidate. I still believe I am a candidate until this court has made its pronouncements as to the way forward. I represent, as a president of a political party, the United Democratic Alliance. This is a far-reaching national issue that is before you, before this court. It is one that is going to define the democratic landscape of our country. It is one which every citizen, every electorate that participated in this election is entitled to have his or her views heard by this esteemed court, my Lord. It is therefore incumbent on me as a respondent to ensure that whatever I bring before this esteemed court is factual, truthful, and representative of the many, many citizens who are entitled to a just, fair, free outcome of this electoral process that is being challenged today. My Lordship, it is important, therefore, that I draw certain averments from one judgment which you passed, my Lordship, between Julius Mawarire versus Robert Mugabe and others. And I quote, "The principle of locus standi is, after all, that it is better to let people have access to the fountain of justice, where they fail for the reasons of their folly, than have them blame the gatekeepers." Unquote. My Lordship, I think it's critical that when our arguments are ventilated, while they don't form an independent application on their own, they certainly would enrich, I believe, if I'm within order, the broader issues that the bench might want to be informed with. That ventilation is critical, not only for the judgment, but for the citizens of Zimbabwe to know that no issue was hidden and was not presented or argued before the court that forms aspects that affect the determination of who governs them. Unless this court is saying, because you did not put your application, and whoever else is a citizen of this country must be muzzled, and their rights, which I represent to a greater extent, must not have any distinctive meaning to this court. My Lord, on Thursday last week, in chambers, right in here, my Lord, you said this case had certain peculiarities that needed certain rules to be made. And indeed, this court is the court of first instance and can make rules to ensure that the democratic rights of citizens of this country are held. And I concurred with you, my Lord, that this is the first such case that this country, or maybe that this region or continent has had. And therefore, specific rules were not available, as you averred yourself last week. My Lord, I think, without being repetitive, I'd like to associate my argument to a great extent with the fifth respondent, but aver that my arguments enrich and also greatly address issues that were raised by the first respondent in his papers that have not been dealt with with the other respondents substantively. I'd like this court to note that until December, I was a member of the political party that had fired the first respondent. And so I know the issues in a much more substantive way, which this court would benefit from by hearing my argument. And it is not only going to benefit this court, but will shape the outcome of the citizens who are not here to represent myself or to speak on issues that I fortunately can speak to. Those would be my submissions, my Lord.
Yes, thank you, Mr. Schumer. Yes, thank you. Can we have the next participant in this group? I think is number 20, respondent 20. Yes, Mr. You are representing number 20.
The 20th respondent.
Yes.
My Lord,
Sorry, you are Mr.
Mnangagwa.
Mnangagwa, yes, Mr. Mnangagwa. Oh, yes, sorry, Mr. Mnangagwa.
Thank you, my Lord. My lords and ladies, the notice of opposition for the 20th respondent appears on pages 781 to 792 of the record.
Of which volume, please?
Of the second volume, my lords and ladies.
Could you repeat the pages again? Sorry.
781 to 792, my lady. And it is the 20th respondent's submission that the notice of opposition is appropriately before this honorable court. The affidavit filed by the 20th respondent clearly indicates that he is opposed to the relief which is sought by the applicant. In particular, he
is opposed to
Yes.
the relief.
Yes.
Oh, all right.
I'll refer you to page 788, paragraph 2. It reads, I have carefully and diligently read the contents thereof and wish to state that I am opposed to the granting of part 2 of the relief sought for the reasons which will more fully appear in the body of this opposing affidavit. My lords and ladies, the 20th respondent was served with an application which he felt if it was granted in a certain form as prayed for by the applicant, it would not be appropriate. And this opposition is what he sought to place before this honorable court. In simple terms, the basis of his objection to the relief sought in part 2, he sought to tell this honorable court why the applicant was not good for the part 2 relief. And my lords and ladies, you would agree with me that he can only do so by filing a notice of opposition and an affidavit. Now, in the course of addressing this honorable court on those issues, he deals with averments by the applicant, and he confirms that he agrees with those averments. As all the other respondents are entitled to do, they are not entitled to deny everything which an applicant brings before this honorable court. They only deal with those specific items that they are opposed to. And when it comes to those items that they agree with, they don't want to detain this honorable court. The essence of the 20th respondent's position is basically that whilst he finds the applicant's position correct in certain respects, it does not entitle the applicant to a declaration that he seeks consequent to this honorable court's decision. And I submit that this can only be expressed through opposing affidavit, which is what is before this honorable court, and therefore it must be considered by this honorable court. My lords and ladies, the application in terms of section 93(1) of the Constitution is a sui generis application, and it's a very important application in the affairs of this nation. One only has to refer to the single opportunity that this honorable court had to decide a section 93 application, that is in the case of Changirai versus Mugabe. That is CCZ 20 of 2017. And this honorable court defined its duty in respect of a section 93 application as to inquire into and established if the alleged acts of corruption or irregularities or acts happened. Now, I pause to emphasize there that this court ruled that its duty is to inquire. And I also pause and refer this honorable court to the jurisprudence in relation to electoral petitions before the introduction of section 93, which again went to the extent that although we have an adversarial system, when it comes to electoral petitions, the court plays to a certain extent an inquisitorial role. And whenever a court plays an inquisitorial role, there is a certain degree in which it moves away from what traditionally is strict practice, so as to allow it to fully inquire into the issue before it and reach a decision that inspires the confidence that all aspects that must be dealt with have been ventilated. In so doing, this honorable court will have to look at all the evidence before it. And this is the latter part of the dicta in Changirai versus Mugabe, where it says, the court satisfies its duty by hearing evidence and assessing it in accordance with the competent rules of analysis. Now, as far as the 20th respondent is concerned, he gathers from the applicant's papers and from facts that he knew before that the applicant cannot be good for certain aspects that it seeks this honorable court to grant him. And so he proceeds in his opposing affidavits to set out and concludes in, if you can bear with me, my lords and ladies, in paragraph 11, that the applicant is not good for the relief in part 2, as he, like any other participant, did not garner enough votes for such a declaration. And that is his main contention. But to get to that, he has to pass through an analysis of what he received from the applicant. He has to make reference to certain items that he received from the applicant so that he can adequately make his point. He was at a risk if he had not opposed this application, that which he feared, that which he did not want, might be retained by this honorable court. And so he cannot be put out of the court when he has a genuine fear that part of what this court may retain is contrary to what the facts in his knowledge show. So he came to this honorable court. And so he filed the documents which he filed. And it is the duty of this honorable court to look at those documents using the rules of analysis that this honorable My lords and ladies, those will be my submissions.
Yes, thank you. Thank you, Mr. Magenta. Now, we have heard the submissions in respect of the issue that we raised. What we'll do now, we'll give just 5 minutes to the other parties to express their views on this matter. We'll start with the applicant. 5 minutes, please, so that we move on.
Thank you, my lord. Lords and ladies, the essential question that is to be answered now, respectful submission, is this. Is a respondent in an application brought under Section 93 of the Constitution, oh, pardon me, my lord, is a respondent in an application brought under Section 93 of the Constitution confined to opposing the application? I must make the point to begin with that an application brought under Section 93 is not an election petition. The Constitution relates to either a petition or an application. The rules then narrow that down to an application. Now, once we start talking about an application, the essential difference between a petition and an application is that in a petition, you deal with the declared winner. In an application, you deal with interested parties. Now, once it is accepted that in an application you deal with interested parties, all the interested parties who are cited have an absolute right to decide what it is that they want to say once placed before the court. The position taken, or the point taken by the first respondent, in respect of which the 23rd respondent joins itself in chorus, is with respect clearly faulty. And this is how it is faulty. It means a respondent in an application brought under Section 93 cannot consent to the relief that is sought. Whilst it is true that in terms of Rule 16, the form, which is CCZ1, invites a respondent to oppose if they are so inclined, it does not debar them from consenting to the relief sought. So at the end of the day, the question which in our respectful submission ought to be answered is whether there is any basis, either in the Constitution or in first principle, for saying to a respondent, if you are brought to court, your sole purpose or the only position that you can take is an opposition. But that, with respect, there is no warrant for that in our submission. I need to emphasize the point that the attitude to be adopted by a respondent is the respondent's and the respondents alone. It cannot be informed by what the applicant says. It cannot be informed by what a fellow respondent says. Neither, with respect, can a court say to a respondent, thus far can you go, and no further. I also wish to make the point that consenting to an application is not bringing an application. You have respondents before the court who say, whereas we could not bring an application, whereas we did not want to bring an application, whereas we had no basis for bringing an application, we have read this application. And having read the application, we believe the applicant is not backing mad. We believe the applicant might be correct. There is nothing with respect that stops that from happening. Now there's an important issue that has been asked. What then happens when a respondent raises an issue which has not been raised by the applicant? Now I want to place two quick responses before the court. In terms of Rule 45 of the Constitutional Court Rules, which allows the court to make reference to the rules of the High Court, by Rule 235, if after an answering affidavit has been filed by an applicant, one of the parties takes the view that there is something before the court which merits an answer, an avenue is created in terms of Rule 235. And the avenue created in terms of Rule 235 allows an aggrieved respondent, allows a respondent who otherwise would be prejudiced to seek leave from the court for purposes of filing a document. I also wish to make the point that for practical purposes, and should the court believe that there is some ganging up. So it's an allegation that has been used. There is nothing that stops the court from saying the respondents who are not opposed to the application shall, for purposes of argument, be treated as applicants. Indeed, that was the approach taken correctly in our submission by Mafusire J in the Grandwell matter, where he said we'll treat you as an applicant, but with the important rider that you are deprived of the right to reply. So that would be the only practical way out. Ultimately, this issue goes to the question of the right to be heard. I understand that.
Right.
1
Sorry.
minute. My Lord, can I get 30 more seconds because of the intervention?
You are still within your time. I'm sorry. You may proceed.
Lord, ultimately, this goes to the right to be heard. By the Constitution, by Scripture, by all standards that pertain to the resolution of mortal disputation, anyone who has an interest in the matter has the right to be heard. And the right to be heard rings ever so wants to say things which are unpalatable. So I close. Lord, might I just have 30 seconds? I'll not go beyond that. Just 30 seconds, my Lord.
How many minutes?
30 seconds.
Sorry?
I do not even need a minute. 30 seconds.
30 seconds?
30 seconds, my Lord.
All right.
I'll be done in 30
No,
seconds.
all right, I'll grant.
The court would have noted that first respondent's position in his opposition is that the applicant is backing mad. All the other contestants in this election are satisfied with the result of the election. So he was happy for all the other contestants to come before the court and say, we are satisfied. But once they agree with the applicant, he suddenly raises all manner of noise, he suddenly raises all manner of dust. That, with respect, is totally unacceptable. Lords, ladies, those are my submissions.
Yes, next, the respondent. Let's have Mr. Wariri, yes.
Thank you, Chief Justice. My lords, my ladies, we make 3 points. And for the avoidance of doubt, these 3 points also relate to the 6th respondent, who, although before this court has said that he is not going to participate, he has not withdrawn his notice of opposition, in which he prays for substantive relief. I'll draw the court's attention to volume 2 of the record. Paragraphs 10 at page 542, paragraph 20 at page and the prayer that he makes in any must also relate to opposition.
Sorry, can you repeat those, Mr. O'Reilly?
Yes, my lord. I refer to 542, paragraphs 3, paragraphs, and paragraph 10. I also refer to page 543, paragraph 20, and the closing prayer which is for substantive relief, ordering a rerun. My lords, my ladies, we make 3 points. The first is that the purpose of a notice of opposition is to oppose. The second is that substantive relief cannot attach to a notice of opposition. And the third is that these respondents are aggrieved losing candidates who were enjoined by Section 93 to file their own separate applications if they wished to challenge the declaration of the first respondent as the President of the Republic of Zimbabwe. The starting point is not Form CCZ1 as suggested by my learned friend, Mr. Mpofu. The starting point is Rule 17, Sub-Rule 2 of the rules of this Honorable Court. Rule 17.2, my lords, my ladies, reads as follows. The notice of opposition shall be supported by affidavit deposed by a person who can swear positively to the facts, which details the facts and the basis on which the respondent opposes the application. That is what I highlight, my lords, my ladies. The notice of opposition must be accompanied by an opposing affidavit which sets out the facts on which the respondent opposes the application. The answer to my learned friend, Mr. Mpofu, as to whether a respondent is restricted to opposing in the circumstances in castle is Rule 17.2. He shall set out the grounds upon which he opposes. Having said that, my lords, my ladies, substantive relief cannot attach through a notice of opposition. Each of these respondents prays for substantive relief. Each of them prays that the election of the first respondent be set aside. My lords, my ladies, in the Indium case, which we cite in paragraph 22 of our heads of argument, this court indicated that a plea is a defense.
What case? What case?
Indium, my lord, at page 5 of our heads of argument, Indium Investments Private Limited versus King's Haven Private Limited and others, 2015-2 Zimbabwe Law Reports 40, and we rely on the passage at 443F. Incidentally, Mr. Daniel Shumba was the second respondent in that matter. And the clear holding of the court was that substantive relief cannot be granted on the basis of what is in a plea. It is a shield, it is not a weapon. The final point that we make is simply that these respondents are, in fact, applicants. They are persons that are aggrieved by the declaration of the first respondent as the president duly elected of the Republic of Zimbabwe. If they wished to challenge that election, they had 7 days within which to do so in a prescribed manner, which is by application in terms of Rule 22. And what is protected and guaranteed is the right of access by aggrieved candidates who meet the prescribed requirements. My lords, my ladies, I relate to the judgment in Changirai versus Mugabe, CCZ 20 of 17, cited in paragraph 23 of our heads of argument. And we also relate to the academic writer Parker, cited in paragraph 24, where he says no questioned except by election petition presented in accordance with the law. As I sit down, my lords, my ladies, I relate to the submission by my learned friend, Ms. Mabwe, that the respondents have no right to reply to these applicant respondents because what they have said is already in the founding affidavit. This is incorrect for several reasons. The first is that they introduce new evidence in respect of which the first respondent has had no opportunity to relate to. The second is that that submission is akin, my lords, my ladies, to suggesting that a plaintiff who testifies, my lord, the Chief Justice, if I could have 2 minutes to wind up. As it pleases. my lord.
Yes.
It's akin to suggesting that a plaintiff who testifies and then calls a witness to corroborate that, that plaintiff, the corroborating witness cannot be cross-examined because the plaintiff has been cross-examined. That is contrary to principle. That is contrary to law. The purpose and meaning of Section 93 was discussed in Shangirai judgment we place reliance on. And sadly, anyone who is aggrieved by a return can only do so through the medium of an application pursuant to Section 93(1) of the Constitution. My lords, my ladies, those would be our respective submissions unless you wish us to address any further or specific aspects of our submission.
An argument has been raised by Mr. Mpofu that what in essence the other respondents did was not to file opposing affidavits, but to be it in a very detailed way. What is your response to that?
My lady, this was not simply to consent to the order. The primary relief, my lady, that is sought by the applicant is that he be declared to have won the election. They say, no, let us have a rerun. That is not consenting.
Is that then opposition? Do you then consent that it is opposition?
It is not opposition, my lady.
What about the submission by Mr. Mnangagwa that the 17th respondent was entitled to file these papers because he does not agree with, I think, relief 2 and 3 in the applicant's draft order?
My lord,
in other words, the 17th respondent is saying, yes, the election should be set aside, but I do not agree that they're the winner. Instead, there should be a runoff within 60 days. That is my understanding of that submission.
The underlying, my lord, the underlying premise of that submission is a complaint against the winning candidate. And that complaint can only be raised through an application in terms of Section 93. Again, what is sought is substantive relief, which cannot be sought through the medium of an opposing affidavit. The fact that the 20th respondent has been cited, my lord, does not make him an interested party. My lord, we make the submission that the interest is a legal interest. And Section 166 of the Electoral Act defines a respondent. And my lord, it defines a respondent in the following terms. In this part, respondent means the president, a member of parliament or councillor whose election or qualification for holding the office is complained of in an election petition. The meaning and purpose of this section was related to by Kujiga J in Simbarashe versus Zimbabwe Electoral Commission and another, 2008, 1ZLR 342. My lords, my ladies, we rely on a passage that appears at page 351 C to E, where is the citation, my lord, is Simbarashe versus Zimbabwe Electoral Commission and another, 2008, volume 1 of the Zimbabwe Law Reports, 342, a decision of the High Court, and we refer specifically to a passage at 351 C to E, where Mr. Justice Kujiga says, and I quote, "The aim and object of defining respondent in this limited fashion appears from the very nature of an election petition. It is a challenge against the actions of the winning candidate before, during, and after an election. In other words, at the center of an election petition is the winning candidate. And Parker, whom we have cited at page 7 of our heads of arguments, paragraph 23.3.2, says that the respondent is the member whose election or return is complained of, and sometimes the returning officer. A person who claims to have been elected and who acts as if he had been elected may be made a respondent. And we emphasize the following passage. But an unsuccessful candidate who does not assume to have been elected cannot be made a respondent. And reference is made to Lovering versus Dawson. So we submit, my Lord, in response to the question that has been raised with us, that these respondents are not respondents properly so called by dint of section 166 of the electoral law, and they cannot seek to argue their own cases as if they were applicants. If they intended to be applicants, the Changirai judgment is clear. They had 7 days to file their own petitions. They did not do so. They are out of court. Their papers ought to be struck off, and we pray accordingly.
Yes, thank you.
As it pleases, my Lord.
Yes, Mr. Kanengoni.
Thank you, my Lord. My Lord, the position that's been taken by the 23rd, 24th, and 25th respondents in this matter is that the opposing affidavits, so-called by the respondents that have been addressing the court before we came in, should not be made part of the record. They should be struck out of the record. They are not properly opposing affidavits as that term is defined in our law. My Lord, the two forms that the court should look at from the rules of court in determining this particular matter are Form CCZ1 and Form CCZ2. The first form being the court application itself, which effectively calls upon every respondent in the matter, cited in the matter, who wishes to oppose, and I emphasize, my Lord, who wishes to opposing papers. Form CCZ2, in turn, is given particularity by the rules of court, particularly Rule 17, Sub-Rule 2 of the Rules of Court, which specifically indicate that any respondent who files opposing papers should put the details of his opposition, effectively the reasons why he is opposing the matter, not reasons why he is supporting an application. On that basis, my lords and my ladies, the papers that have been filed before you by the respondents, so-called, I believe 20th, 6th, and 5th, are not in essence opposing papers. What they are founding affidavits for their own versions of a petition that they did not pursue in terms of Section 93 of the Constitution. Now, if we go to Section 93 of the Constitution, the time limit that is set therein of 7 days applies to every aggrieved candidate. If you are a candidate that wants to challenge the election return in the presidential election, you must act within 7 days. If you do not do so, you apply to the court through your opposing papers, so-called in this particular matter, and try and place your own substantive relief before the court to be granted as if you had pursued your rights in terms of Section 93 of the Constitution. The argument has been placed before you, my lords and my ladies, that a respondent is at large to consent to any relief that has been point that must be made is that from the submissions that we have heard from the 20th, 6th, and 5th respondents before you right now, is that they strenuously disagree that they are consenting to the applicant's relief. They go to great lengths to indicate that they are actually not agreed with everything that the applicant wants, and they themselves have certain relief that they have placed before the court, which they want the court to consider. For instance, my lords and my ladies, if we go to the second volume, at page 789 of the second volume, you will find the 20th respondent's own very detailed that he seeks before the court. What he does and what his fellow respondents in the same vein do is to essentially try and apply before this court. They do not consent, but they present a counter application before the court under the guise of a notice of opposition. That, with respect, is not allowed. It cannot be countenanced in a Section 93 application. The rights that are given in Section 93 are given to each candidate. They must be pursued individually. If they wanted to come as applicants, they could have joined the applicant in this matter and have been co-applicants within the 7-day period that is prescribed. They did not do so. As such, any papers that they present which are in the form of something like a counter application should be disregarded by this honorable court. They are out of time, they are out of court. Further argument has been placed before you that the provisions of Rule 235 of the High Court rules allows that a respondent may file a further affidavit following the filing of an answering affidavit. But the difficulty with that submission is that it relates to answering new issues that have arisen in an applicant's answering affidavit. They do not relate to respondents inter se. Respondents cannot respond to another respondent's opposition as if it is an answering affidavit. The moment the necessity of that arises, then a question must be asked as to whether what has been filed as opposition is in fact opposition, if it requires a fellow respondent to now address it as if you are now addressing another applicant that has filed papers before the court. This characteristic effectively belies the true nature of the papers that have been filed by the 20th, the 5th, and the 6th respondent in this matter. They are founding papers. They are a counter application before the court, filed somehow outside the parameters of Section 93 of the Constitution, and they try through the back door to bring their own petition, which they failed to do. Their failure must visit them, and their papers must be removed. They must be struck off. My lords and my ladies, those are would be our submissions on the issue of the various affidavits that have been filed by the 20th, 5th, and 6th respondents, and I believe the 17th as well.
Yes, thank you. Is there any other respondent who would seek to respond? I think we are done now. I will just give the 4 respondents just 5 minutes if you are really dying to make a reply to what has been said by the other respondent. That is if you really feel that you would want to say something.
Thank you very much.
So if you can just confine yourself to the 5 minutes, please. We don't.
Thank you very much, my lords and my ladies. I will relate to 2 issues. The first issue is the definition of respondent is argued by my learned friend, Mr. Uriri, and he refers to Section 166 of the Electoral Act. My lords and my ladies, I submit that the application before you is not a Section 166 application, and the definition submitted by my learned friend of a respondent would therefore not apply. The application before you is a Section 93 application. I come to the Section 93. The submission also made by my learned friend is that the starting point is Rule 23 of the rules of this honorable court. I submit that the starting point is rather Section 69 of the Constitution of Zimbabwe, which section guarantees to every citizen the right to a fair hearing. And once a citizen has been brought before the court, as a respondent, their right cannot be taken away. And the court should interpret its rules so as not to take away a right that is constitutionally entrenched. Unless there are other issues, those will be my brief submissions.
Yes, thank you. Mr. Chumba, do you have anything? You don't have to. If you feel strongly you want to say something, you are free to do so.
No, my lord, except that the first respondent is trying to import the sixth respondent whom you have already excused from the court. Thank you.
Yes, I think you want to say anything, Mr.
Briefly,
Mnangagwa?
my lords and ladies, the point has been made about the fact that the respondents have what appears to be prayers in their affidavits. My lords and ladies, the simple point which is being made is that whilst we are opposed to the application, we know that this honorable court is at large to make whatever order it may make. And we express that based on our knowledge, this would be the appropriate order that this honorable court can make. It does not detract from the fact that we are opposed to that which brings the applicant before this honorable court. And certainly that would be my brief response, ma'am.
Yes, thank you. Minutes, 15 minutes.
Say 20 so that we can have a quick cup of
20 minutes. And we can round it up. Yeah. Just like that.
Judge Mugao says 15 minutes.
15,
That's what she says.
Yes, thank you. We have come to the end of this segment of the proceedings. What is left now is for the court to retire, deliberate on the submissions made, and come back after 20 minutes, at 20 minutes exactly, and deliver our judgment on this aspect of the preliminary issue. I thank you. The court